Understanding the distinctions between conditions, warranties, and innominate terms is fundamental in commercial common law, particularly within contract law. These classifications determine the remedies available to parties when a contract is breached. Let's delve into each term, explore their differences, and provide illustrative examples. Conditions. A condition is a fundamental term of a contract. It is so central to the agreement that its breach entitles the non-breaching party to terminate the contract and claim damages. Key characteristics. Conditions are vital to the contract's purpose. Breaching a condition allows for termination, also known as rescission, and damages. Parties expect the condition to be performed as agreed. Example: imagine you enter into a contract to purchase a specific model of a car from a dealer. A condition in the contract states that the car must have a brand new engine. If the dealer delivers the car with a used engine, this breach is significant enough to allow you to terminate the contract and seek damages. Warranties. A warranty is a less critical term compared to a condition. It represents a promise or assurance that a particular aspect of the contract is true or will happen. Breaching a warranty does not typically allow for contract termination, but does permit the injured party to claim damages. Key characteristics. Warranties are subsidiary to the main purpose of the contract. Breaching a warranty entitles the non-breaching party to damages, but not to terminate the contract. Often warranties relate to the quality or scope of work or services provided. Example: suppose you hire a contractor to renovate your kitchen. The contract includes a warranty that the paints used will be of a specific brand and quality. If the contractor uses a different brand of paint, this breach allows you to claim the cost difference but does not give you the right to terminate the entire renovation contract. Innominate terms, also known as intermediate terms. Innominate terms fall between conditions and warranties. The classification of an innominate term depends on the nature and severity of the breach. The remedy available hinges on the impact the breach has on the contract's overall purpose. Key characteristics. Innominate terms have a flexible classification. They are not inherently a condition or warranty and depend on the breach consequences. Breaching an innominate term can allow for termination and damages or just damages based on the breach's effect. The classification is case-dependent and determined by courts based on specific circumstances. Example: consider a contract for the supply of computer software with an innominate term that the software will be delivered by a certain date. If the delay is minor and doesn't significantly impact your business operations, you might only claim damages for any inconvenience or costs incurred. However, if the delay causes substantial financial loss or disrupts critical business functions, you may have the right to terminate the contract in addition to claiming damages. Landmark case Hong Kong Fur Shipping Co. Ltd v Kawasaki Kisen Kaisha Ltd in 1962. This case introduced the concept of innominate terms. The court held that whether a breach allows termination depends on the breach's effect on the contract's overall performance, rather than classifying the term as a condition or warranty outright. Comparative summary. Why the distinction matters. Understanding whether a term is a condition, warranty, or innominate is crucial because it dictates the legal remedies available. For the breaching party, they need to know the potential liabilities, whether it's limited to damages or could involve contract termination. For the non-breaching party, it influences the strategy for enforcing rights, whether to seek termination, damages, or both. Contract drafting parties can intentionally classify terms to specify remedies, although courts may reclassify based on the breach's reality. Practical tips: clear contract drafting. Clearly define terms as conditions or warranties where possible to avoid ambiguity. Assessing impact. When dealing with innominate terms, focus on the actual consequences of the breach rather than its classification. Legal advice. In complex scenarios, consult legal professionals to interpret the nature of terms and appropriate remedies. Understanding these distinctions enhances your ability to navigate contractual relationships effectively, anticipate potential disputes, and implement appropriate legal strategies when breaches occur. Make the background music epic.